Hi, everybody. This is Jeff Fowler with the Apartment Owners Association, and we have a recording of a landlord-tenant attorney speaking on how to avoid discrimination lawsuits and also just some of the new laws that impact how we all do tenant screening. So before we get started with that, I do want to mention a new AOA tool that we have that's part of AOA tenant screening, and it's an income verification report. And I know we're all aware of Photoshop and how people can change their bank statements. And many of you are aware that there are software platforms out there that will create a pay stub for you. And just with that in mind, it becomes more important to be able to cross-reference these documents that you're receiving from applicants with a trusted source. And so we have a way now to verify that income with this income verification report. So I want to encourage you to use that, just even knowing it's available. I hope that's something that helps you. And our speaker today, again, he's a landlord tenant attorney in the San Diego area. He writes the legal Q&A for the AOA magazine, and he's been in business for literally decades at this point. And so he is an expert and really able to speak on the topic. It's not legal advice, but it's general information. And really our goal at AOA is that we would give you information that helps you avoid the headaches and get the very best possible tenants into your units. And so we hope this helps. Thank you so much. We hope you enjoy it. Take care.
You cannot raise it more than 10%. As you guys know, in the last 2 or 3 years, we've had multiple state of emergencies, first with COVID, then fires, then floods, you name it. So if your county is in a state of emergency, technically you cannot raise your rent more than 10% during the time that the state of emergency is in effect. Now, everybody's aware of rent control laws that have passed recently in COVID. That's something different. And so you might have, let's say, a house or a condo that's exempt from those rent control laws. That's fine, but every unit, this statute applies to every unit. So I just need you to be aware of it because basically no landlord is aware of this one particular statute. So if you're currently in a county where there's a state of emergency, you're not able to increase the rent 10%, even though your unit might be exempt because it's a condo, a house, or was built within the last 15 years. So when you're looking to advertise a unit, what can you do and what can't you do? So you can't discriminate against certain classes of people. And it's basically written up there: race, color, religion, sex, sexual orientation, national origin, source of income. We're going to talk about that because that's a new one. And you can basically see the rest of it. So questions asking those things, you're not allowed to ask. So don't ask. Don't put it in your advertising and don't put it in your application. Sometimes where does this creep up? Let's say you've been a landlord for 40 years and you've been using the same rental application for 40 years. I would really take a look at that rental application because it probably asks questions that you're not allowed to ask. So an example might be, are you married or single? You're not allowed to ask that. So if you look through your application and you see that's very old and it starts asking some of these questions, just discard it. Go to the Apartment Owner Association, get their rental application, and then that way you can make sure that you're not asking a question that's illegal. The other thing might be disability. Sometimes that's one. You're not allowed to ask what a person's disability is. You can inquire, are you disabled? If they say yes, that's fine. You can demand that you get a letter from a health professional, right? And if they require some type of modifications to your unit, then you basically have to enter into a dialogue with them to see if you can try to accommodate their disability. Let's say the person's disabled and he's in a wheelchair, right? And he's in a wheelchair. So in that situation, let's say you have 1 or 2 steps that's going up to the house he's going to rent. And he comes to you saying, hey, I'm disabled, I'm obviously in a wheelchair, I want to build a small ramp. You cannot say no. What you need to do is enter in dialogue with them. Well, what type of ramp are you thinking about? Well, I was thinking about doing X, Y, and Z. You go back and forth and talk about it, and you can eventually come down to the point of, look, I'll let you build a ramp, but I'm going to request that you have a contractor do the ramp, that it's done correctly with the permits, right? And that they have insurance in case something happens, the contractor injures himself or someone else, that it's going to be covered by your insurance. So basically, you're allowing them to do it, and you're just basically making certain requests of them, and you don't have to pay for it, right? So you can have the person pay for it. So same thing, let's say the person requires bars in the shower, because it helps them get in, taking a shower with the bars in there. Same thing. Hey, I want to put the bars in, I'm just going to do it myself. No, I'm willing to let you put in the bars, but I'll use my contractor, you pay him, or I want to see the person's license, and you kind of enter in that discussion with them. Don't say no immediately. It's kind of more back and forth. That's what the law requires you to do, okay? You can't, let's say sometimes you can't see the person's disability, and the person says, I'm disabled. No, you're not, right? What's your disability? That's bad. It's very bad. If they say they're disabled, say, okay, great. You're requesting certain things. Let's say you're requesting bars in the shower. That's fine. Give me a note from your health professional. Doesn't have to be a doctor. It could be a nurse. A health professional, it basically says that you require these bars in the shower because of your disability. So don't ask what the disability is. Okay, fair enough? So obviously when you're doing advertising, you're trying to post advertising, you got to be aware of that. Now there's one exception to that. Let's say you're living in an apartment or you're living in a house and you want to rent out one of your rooms. You can restrict the sex. So if you're a woman living in an apartment alone and you want to get a roommate, you can say, looking for a female tenant to share an apartment with. So you're allowed to do that. Now, we're going to talk a little bit more about the source of income. What does that mean? You can't discriminate against it. What was happening in the past was when tenants came forward and let's say they were on Section 8. Section 8 is a federal program where the federal government pays a portion of the rent or all of the rent on behalf of the tenant, okay? So that's how the tenant would pay the rent. And in the past, the landlord had the right to say, I don't want a Section 8 tenant because of the additional administrative hurdles, etc. Several years ago, there was a case that went by, and basically the case held, look, you can't discriminate against people. I'm sorry. Basically, the case said that the landlord can discriminate on this basis. The state legislature passed a law saying a landlord can't. So if the tenant comes to you and say, look, I make $1,000 a month because I work part-time somewhere, and Section 8 is going to give me another $1,500, you need to look at both of those incomes when you're determining whether or not the tenant qualifies for your unit, okay? So you can no longer say no Section 8 tenant. What happens if you put an advertisement, let's say on the internet or somewhere else, where you basically say no Section 8? What will happen is you will get sued. There's tenants, attorneys out there. All they do is scour the ads. If they see those magical words, you're gonna get sued, and you're gonna come to me and say, I got sued because I had these ads up. And you're automatically going to be guilty. Why? Because they already have proof that you advertised it and you stated no Section 8. And at that point, we're basically going back and forth, and I can see how fast I can get you out of the lawsuit, and as with little money as possible. So no longer put no Section 8. Let's hold the questions until the end, okay? So that's what you got to be, that's what it means by the source of income. So basically, the source of income, whether it comes from the federal government, the state, local authorities, any type of housing program, it's all going to be considered a source of income, okay? Now, besides that, sometimes people make income doing other things which are legal, okay? That also applies. Hey, you're in a certain line of work. You're a dancer, a special dancer, let's say. I don't approve of that. I don't recognize that income. You're not allowed to do that as well. So it's not only government subsidies, but also maybe other income that people get. Hey, I work in a marijuana shop, and I sell marijuana to people. Well, I believe that's wrong. Same thing, you're kind of judging where the source of the income comes. Now, the city of San Diego has a little bit different definition than the state does. And basically, the city of San Diego also includes any nonprofit money that comes from nonprofits. So there's a lot of nonprofits in the state now that provide rental assistance for tenants. So again, you cannot discriminate saying, hey, you're getting your money from a nonprofit. I can't count that extra $1,000 that they're chipping in every month to determine whether or not you're eligible to rent my space. Okay, so that's what we need to deal with advertising. So take a look at your advertising. If you haven't say anything dealing with no families, no kids, obviously the obvious ones dealing with race, you guys know that's wrong, no Section 8, so take a look at that and make sure it gets cleaned up. Now, the next thing you want to do is, let's say you advertise a unit and you start having applicants apply. Okay, what do you need to do in that situations? Okay, the biggest problem landlords get into, they know all this stuff I'm about to cover, but they don't do it, right? So when you guys come to me and say, look, I need to kick out this person, and I see it's a very bad person, and I'm like, why did you rent to him? Did you run a credit check? No, I didn't. Well, did you check to see he actually worked somewhere? No, I didn't. Did you actually see the person that you rent to matched or saw his ID that is actually the person that he says he is? No, I didn't. Well, that's why you're here. And they know they did wrong, and they come to me, and I don't make them feel too bad, but that's when you get into problems, okay? Be careful of the red flags. If the tenants are trying to rush you, it's a red flag, right? Hey, the unit's gonna be ready in a week, you tell the tenant, and the tenant goes, well, no, it's no big deal, I wanna move in 2 days. And basically they're rushing you to get the unit ready. You haven't completely repaired it, you haven't completely cleaned it, and they might say things like, well, don't worry about it, I will clean it, I will repair it. That's a red flag. A lot of times what happens is they get in there and they're rushing it because they're getting kicked out somewhere else. And then they go in there, you might get 1 month's worth of rent or maybe no rent at all, and they turn around and send you an email saying, I can't believe it, when I moved into this unit, it was uninhabitable. It wasn't clean and there's a bunch of repairs to be done, here's a whole list. And you're gonna be like, well, wait a minute, you told me you were gonna clean it, you were gonna repair it. No, I didn't. The ultimate duty of having the unit clean and repaired is the landlord's, not the tenants. You can't shift it. If they say they're gonna do it, they might do it. Maybe you have a good guy or a good gal. A lot of times they won't, and they're gonna hold it against you that you rent them a unit that wasn't habitable, wasn't repaired, and it wasn't cleaned, right? And then right off the bat, you're dealing with having to repair and clean the unit while the tenant's in there. They're not paying the rent. They're never gonna pay you the rent, and they're basically gonna be there the next 6 to 9 months while I try to kick them out. So do the steps that we talk about, make it a habit. It really avoids a lot of the issues, time, and money. Currently in the city of San Diego, it's taking me between 4 to 6 months to evict somebody. And that's just a straight eviction. That means they don't file bankruptcy. They don't try to remove the case to federal court. They don't do a lot of these other delay tactics. The sheriff in San Diego is taking, when we give them the writ is a writ of possession, is instructions from the court to the sheriff to do the lockout. We typically get the writ after we go to trial or we enter a default judgment against the tenant. It's taken the sheriff's department 2.5 months to go out there and kick somebody out, right? So we get them, you serve your 30-day, 60-day, 3-day notice. We file the action, we get them served, we have the trial, we have a default. Hey, it's been a month and a half, 2 months, maybe 3 months. And all of a sudden it's like, okay, we're waiting for the writ. The court clerk is taking 2 to 3 weeks to issue the writ. We get the writ, we throw it to the sheriff, 2.5 months more wait. Okay, so it's important to make these screenings because the people that are jumping around are typically the same people. I kick out a lot of the same people over and over again. I kick them out of one residence, they go to another house that happens to be my client as well. I kick them out again. Some of these people I'm on first name basis with them because I've kicked them out 3 or 4 times, right? So let's try to make sure to follow these things. Okay, have all the adult applicants fill out the rental application. You need to know who's in your units. Obtain a credit report for all adult applications. You need to pull the credit. Verify all the information on the rental application. What are you going to verify? Who they are. Are they actually Mr. and Mrs. Smith? Right? Do they actually work for ABC company? Actually call and see if, the information is correct. And the last thing is you got to get a copy of the photo ID. A lot of cases, we find out down the road, he says he's Mr. and Mrs. Smith. You don't never see a photo ID. Later on, we find out it's actually Mr. and Mrs. Warren, right? And Mr. and Mrs. Smith is their friend who happens to have really good credit. So when you pull the credit and you pull the Social Security, it comes out nice. But they're not the Smiths, they're the Warrens, right? But if you request a photo ID, a California driver's license, whatever they want to give you, even a passport, you can see that the person in front of you is actually the person that's filling out the rental application. Does this really happen? Yes, it does. It happens a lot. So let's get the photo ID. What factors can I use when I'm screening a new applicant? Okay, they're starting to limit this, as Jeff was talking earlier. So credit standing, yes, you can do a credit check. Employment history, you can still basically see the person's employment history. Obviously, somebody's working at a job for 6 months is not as strong a tenant as somebody's been working at the same job for 10 years. I think everybody's aware of that. The amount of income, not the source. Hey, I make $2,500. What is that a month? What is that made up of? $1,500 labor and $1,000 from some organization. It's the same thing in your eyes and in the law's eyes as someone else who just makes a straight $2,500 a month through their employment. Rental history. Is this their first place? They've rented somewhere else for 10 years. Okay, great. Obviously, the person is there for 10 years. You can call the previous owner. You will call the previous owner and ask some basic questions. If they come back to you and say, I can't answer any of your questions, is that a white flag or a red flag? That's probably a red flag, right? If they and so let's call up the previous landlord to just double check. Also, you can review personal references, past bad conduct. So this is what Jeff was checking out, mentioned earlier today. Past bad conduct meaning criminal behavior. They've really limited what you can do in reference to criminal behavior. And they basically focused it down to, well, the behavior that's relevant in making your decisions to rent to a person is whether or not it affects the health and safety of the people in your other rental units. Does that make sense? So let's say he broke into another unit. That's something related. He harmed his neighbor somehow. What if he got in an automobile accident and a hit and run? Does that really relate to anything dealing with your tenancy and the safety of your other tenants? Probably not. Okay, and then we're going to go over a little bit more about the actual law and how impossible it is for you guys to follow the law the way they have it set up. Let's move to the next one, and we'll cover that. No, I think you skipped one. Go back. Questions to ask? Next one. Okay, so question is, did they, when you're calling for the rental history, did the applicant pay rent on time? Did they take care of the premises? Did the other tenants make complaints about the applicant? Did the applicant follow the rules? This is what you need to talk to the other person. Again, if they don't want to give you certain information, it's a red flag. Sometimes what the landlord would do is say, look, this is the most I'm willing to do for privacy reasons. He was my tenant. He was my tenant for 2 years, and when he left, his rent was $2,000 a month. They might do that as well. That's a semi-red flag. But with that, I do understand some landlords want to keep certain private information private, and so you need to weigh what you think the situation is. Okay, let's go to criminal backgrounds. So basically, this is how impossible it's making it for you guys. You can't use criminal bad acts, okay, if it has a discriminatory effect. What does that mean? Let's say this person dealt drugs, right? Hey, he's dealt meth. He got charged for using meth and delivering meth. You're thinking, well, wait a minute. That might be something that directly affects my other tenants if he's a drug dealer, a past drug dealer. You would think. However, you cannot use that information if it has a desperate effect on a particular type of people. Now, I'm making this up because I don't know. So let's say most of the people that get convicted of dealing meth is a particular race, right? If that's the fact, you can't use that as a rental criteria. How in the heck is a landlord going to know what type of criminal offenses have this effect on a particular race? You won't know unless you go rifling through the FBI statistics and trying to figure out how this affects people. So it's basically an impossible standard for you guys to do. So you're basically saying, well, Franco, what the heck are we supposed to do? So I think you need to look at if they have a past criminal behavior and see the closer it applies to tenants, affecting the health and safety of the tenants in your buildings or your other apartments, then the more likelihood you're going to be able to use it as a factor for your rental criteria. Because all the other stuff is, I do not know how the heck you're going to figure out if this particular criminal charge has an effect on a particular class of people. Right? It's impossible. So that's why right now it's a little dicey using past criminal acts. It really is. So I'm just throwing that out to you. I know it's impossible for you guys to follow, but that's what the state of the law is right now. Let's go on. To help you out a little bit, this is the HUD guidelines for criminal background checks, okay? So basically restrictions that indirectly create negative impact on minority groups, you can't use that. Again, how are you going to find this information? And they'll allow you to do if it directly targets a specific protected class, then basically you're not going to be able to do it as well. So if it's indirect discrimination, that criminal conduct or it's a direct discrimination of that criminal conduct, you can't use it. But again, how do you determine whether or not it's an indirect or direct? Either way, you can't use it, but you don't have the statistics to basically follow this requirement. Let's talk about illegal questions. What you can't ask, as we talked about earlier: race, color, religion, sexual orientation. One I want to kind of focus on is age. Typically, you can't ask for age. Some places are especially set up for elderly people. So in that situation, typically it's 62 and over, they can ask how old you are, but except those individual cases, you're not going to be able to ask their age. And just so you guys know, I should have mentioned this in the very beginning, I'm going to have this whole presentation posted on my website, so you don't have to worry about like taking feverish notes or copying everything. You can just go to my website afterwards and you can kind of download the whole presentation. So age, there is an exemption. And also one thing that you can limit is you can limit the number of people in your unit. But this is also a little tricky, right? Why is it tricky? Let's say you have a 3-bedroom and you're like, I'm only going to limit to 2 people. That might be viewed as discriminating against families, right? If you have a husband and a wife, let's say, and they have 2 kids, they won't be able to rent your house or unit because you restricted it to 2. So you got to be careful. But a lot of cities will have certain limitations of how many people are supposed to live in a certain unit, okay? So let's say with the 1-bedroom, I believe in the city of San Diego, I believe it's 5 people. You're not supposed to have more than 5. Now, do you have to follow that? No, you don't have to follow it. But the nice thing about it is you can point to it and say, if somebody sues you, well, why did you restrict it to 5? They're going to say, well, you're trying to discriminate against large families. You're going, no, the reason why I did this is because I'm pointing to this law in the city of San Diego saying, look, you're not supposed to have more than X amount of people in this unit just because of its size. Does that make sense? So in that situation, okay, but don't narrow it down to 2 people. Even a 1-bedroom, it could be considered discrimination against families. Don't say no kids. Here's a crazy discrimination thing. One of my clients had rules, house rules, right? All the tenants are supposed to follow. And one of the house rules was kids cannot play unsupervised in the common area. Sounds reasonable to me. You don't want kids running around. They might break things. They might run out to the street and get hurt. That was viewed as discriminatory against kids. And the landlord got sued, and the tenant won. So, certain things you might not realize are discrimination, right? So you really need to take a look at things and say, is there anything in here that might be considered discriminatory? And that's an example which I was actually shocked at too. Is like, ooh, I can kind of see it going the way of the landlord, but in that particular case, the court believed that it was a discrimination against families with kids. The last thing also, you can charge up to $62.02 to cover the cost of application fee. It has to be your actual hard costs, right? This number changes every year. So let's say it actually only costs you $40 to do what you need to do. Hey, my credit report is $30 plus $10 for something else. So don't overcharge your applicants. Does that make sense? Why do I say that? There's been cases out there where very large landlords, meaning they own 10,000 units, they were basically overcharging like $10 per applicant, and they had a class action suit, and they lost millions of dollars. Because you can imagine 10,000 apartments, they probably had hundreds of thousands of applicants. They overcharged $10 each time, and they got nailed for it. Okay, so if your hard costs are X, charge X. Okay, don't just say I'm going to charge $62.02 and you don't do anything, right? You don't really pull a credit report, you don't spend anything, and you're basically charging people when it's not actually an out-of-pocket cost. Other things are lovely. Let's go next one. COVID. Just so you guys know, you can't discriminate against a person if they receive COVID rental assistance. Okay, so somebody comes to you and said, I rented at this place, and the owner, you talked to the owner said, yeah, he really didn't pay rent. He got his rent paid by some COVID assistance. You can't use that against the tenant. Here's another popular subject. Everybody enjoys this. You like a peacock? Very nice, very lovely. It can be considered a pet and can be considered an ESA animal. Okay, so what's the difference between a service animal and an ESA animal? ESA is emotional support animal. A service animal is typically a dog, okay, that's individually trained to do work or perform tasks on the benefit of a person with a disability, okay? The best example is basically a eye-seeing dog, right? A person's blind, they have a highly trained dog. Those dogs are worth $10,000-$20,000 because they're highly trained to assist the person with a disability. That's a service animals, and there's certain laws for that. What you typically are exposed to is the emotional support animal, okay? Emotional support animal is other trained or untrained animal. It doesn't have to be trained. It's not worth $20,000. It could be a peacock. It could be a cat that do work or perform tasks, provide assistance, or to provide therapeutic emotional support for individuals with disability. This has become a huge problem for landlords. A lot of landlords just give up and basically say, whatever, everybody bring in whatever animal you want because I'm just tired of handling this. But if they do come with an animal, what are you allowed to do? You're not allowed to ask what the person's disability is. They can say, I'm disabled and require this pet. Great, you can ask for a letter from a health professional, which the health professional basically has to say and has to have seen the person at least 30 days prior to them coming to you, okay? With a note or letter basically saying this person needs this dog, cat, peacock, whatever it is, because of their disability, okay? And of course, they have to be a health professional, so you can check to make sure they're actually a health professional. Is this a real doctor? Is this a real nurse? And you can request that they provide that information. You can also impose reasonable rules for this dog. Let's say it's a dog, right? Just because it's an emotional support animal doesn't mean the dog can bark all night. Doesn't mean the dog can poop all over the place, okay? So you can say, look, your dog's barking all night, it's causing a nuisance, you need to take care of it, or else I'm gonna base that as a reason to kick you out. Or, hey, your dog is pooping everywhere. You need to clean up after your dog. If you don't, I can use that as a reason to kick you out. And I've kicked out tenants who have ESA animals that were not properly being taken care of by the owners, right? Now, I know it's going to be a battle, right? So before we even file the eviction, I tell the owner, look, every time you see a poop out there, I want you to take a picture of it. You need to take a picture of the poop every single time. So we did it for a couple months, and now we have 30, 40 pictures of poop just laying there for days on end. Hey, we're going to give you notice, you need to clean up after your dog. The owner doesn't do that. We start an eviction, we kick the person out. Of course, what did they do? They run to HUD, they file a complaint, they come back to us, and you discriminated against the person because they're disabled, because they have the dog. No, we didn't. Here's my evidence. 50 pictures of poop over the last 2 months he didn't pick up. And they're nice pictures, right? And of course, that got the claim shut down real quick, but if we weren't prepared, they're not paying for the investigation through HUD. You are paying me to fight this. So it's a little imbalance there, right? But if you're on top of things and you get the right evidence, the HUD will drop it, okay? But if you don't, it's basically going to be your word against the tenant's word, and that's not a good position to be in. Let's see. Well, what if you have a service animal or an ESA animal? They're not considered pets. So when you have in your lease, your little clause in your lease, no pets are allowed, and the person has an ESA animal, that's not a pet. It's an emotional support animal. So it doesn't fall within the pet definition of what your lease clause says. You cannot ask for an additional deposit. Hey, your deposit's $1,000. I'm going to add $300 because you have an emotional support animal or a service dog. You can't do that either. Or pet rent or whatever else you want to call it. You basically have to treat them the same as another person who's not disabled that's on your property. Now, there is a rare occasion that you can deny certain animals. And usually this falls into the case of pit bulls. So sometimes, let's say, hey, I have 2 pit bulls as my emotional support animals. The problem with that is some insurance companies won't insure apartment buildings if they have pit bulls, right? So if you can show that there's an undue financial burden on you because of these animals, you might have a way to get out and say no to the ESA animal. Does that make sense? But that's the rare occasions. There's been a couple cases where the courts say, okay, you're right. The landlord can't find insurance because nobody wants to insure 2 pit bulls. And so it wouldn't be fair to basically tell the landlord, you're forced to take this and not have insurance. Okay, what are some of the red flags? We talked a little bit about these. The applicant doesn't complete the full application. That's a red flag. The applicant's pressuring you to let them move in quickly. That's a red flag. Applicants unable to verify name with a government ID. That's a red flag. Now, everybody should be able to get a picture ID in the state of California. So there's no reason why they can't get a picture ID. It doesn't matter what citizen of what country they are, they're able to get a picture ID. So they come to you and say, oh, I can't get one because of X, Y, Z reason. That's not a valid reason. They can get one. So there should be no reason why they can't run to the DMV and get and prove who they are and get the photo ID. Also, when you're calling up and verifying employment and you get a bad feeling, that's your conscience, that's your soul telling you that there's something wrong here. What could potentially go wrong? Hey, landlord, I work at ABC Corp. Here's my supervisor, Jim. You call up Jim. Hey, Jim, how's it? Oh, he's working 5 years, blah, blah. Doesn't sound right. It's probably not his supervisor, and Jim probably doesn't work at ABC Corp. What can you do? You can check the phone number, right? If he works for ABC Corp, Google it and say, hey, what are their typical numbers worked, right? And then call through the number that you got through the Google, right? So Google ABC Corp is blah, blah, blah phone number. You call up, does Tenant Smith work there in sales? Yes, he does. Okay, great. No, we don't. We don't have anybody of that name in sales, right? So you might get conned because you're calling a friend of the tenants when you're trying to verify the employment income. Fair enough? Okay. Also, obviously, if they filed bankruptcy in the past or they've been evicted, you really gotta, I probably wouldn't take them, but that's your decision. But that's a major red flag if they file bankruptcy and they fail to, if they got evicted. Okay, what if you've gone through all these things and you want to say no to the applicant, right? You got 2 or 3 applicants, you picked one, but you said no to 2 other ones, okay? Typically, you don't have to give a reason, okay? But if the person's rejected because of something you found out in some report, okay, then you're required to basically send an email or a letter to the tenant, giving them the name, address, and telephone number of the credit reporting agency, a statement to them saying, look, the reason why I denied you, I got this credit report from this agency, and it showed X on it. It showed that you filed bankruptcy, or it showed you had a judgment against you, or it showed whatever it did. And then also a statement that within 60 days, they have a right to obtain a free copy. Why is this law set up this way? Because sometimes the credit reporting agencies screw up and they post invalid or false things on people's credits. So this was a mechanism that the state legislature said, look, sometimes the tenant will never know they have a bankruptcy on their record and they never file bankruptcy. So if they go somewhere and they're denied credit, then at least this might be a mechanism to tell the tenant, I denied you because you filed bankruptcy in 2020. And the tenant goes, I never filed bankruptcy. That's not me. Well, I'm sorry, I got to follow what the credit report is, but you get a free copy of it, go to the credit agency, and you can work it out with them to have it removed from their credit report, okay? So you're required to send a letter if you denied them because of something that was something on a report. Now, let's say you denied them because you call where they work, and they said they worked there 3 years, but the person said, no, he only worked 1 year. Okay, you didn't receive that on any report, so you don't have to do this letter. You only have to do the letter if you get a report, and it could be a credit report, which includes litigation, or whatever it is, but if it's a report, you need to give the tenant an opportunity to try to reach out and fix it if it's a mistake. Okay, let's talk about, we're getting closer to actually letting this person maybe move into your place. Leasing and rental agreements, do's and don'ts. The law has changed a lot since COVID started, a lot. I think at the last count, there's been 17 new laws that have affected the landlord-tenant relationship. Congratulations, right? There's federal laws, as you guys know. There's state laws. There's county laws. Each city decided, let's make our own law. You throw in the court, throw in their own stuff, and it becomes a big mess. The laws were rushed, right? Because of COVID. They don't make sense. They're unclear. All the laws conflict with each other. The federal laws sometimes conflict with the state law, which conflicts with the county laws, which conflicts with the city laws. It's been so new, we don't know yet how all these laws are actually going to be determined. Okay, what these particular words actually means. What is actually required of the landlord, right? So it's really tough out there right now. So with leases though, you got to get an updated lease. If you have an old lease, I guarantee you, you don't have certain disclosures in there that you're required to have. So might as well, you know what, I had this lease for 10 years, let's scrap it. AOA has a great lease. Other organizations in the state of California also have leases that they update every year. So if you haven't done it for a while, do it now so you don't get, caught up and because you have an old lease, it makes it more difficult for me to kick out people because of the lease situation, and that happens a lot. You gotta fill it out. You gotta fill out the leases. Sometimes people have very long leases and they don't fill it out. Well, what do you mean by that? Let's say this particular tenant is exempt from the state rent control laws. You're supposed to give them an exemption notice, right? People sign at the bottom, but then in the middle of it, there's a box to check. If you check the box, they're exempt. If you don't check it, they're not exempt. Now, you wanted the document to say that it's exempt, right? But you just fill out the bottle, you never check the box, right? Or let's say a situation of, on the 5th page of your lease, who pays your utilities? It's blank. Well, no. The tenant's supposed to. Well, it's not written in here. How am I supposed to figure this out? So if you're going to use a lease, whether it's you filling it out or a property manager, make sure they understand how to fill it out and make sure they completely fill it out. What I usually find is property managers or let's say managers that are part of your team, they don't have the training to fill out the lease. So I get the lease and it's half filled out. I don't know certain things because it was never filled out, and it makes it very difficult. So if you're going to use a lease, try to get the ones a little bit more condensed, has all the disclosures, and you actually go through and fill in all the spaces. Personalized with addendums, have house rules. Why is that important? The relationship between you and the tenant, 90% of it is going to be reflected, the duties and responsibility in your lease, right? If it's not in your lease, I can't enforce it, okay? So some of it is house rules, right? Hey, you can't be in the pool past 10 o'clock. Let's say that's a house rule, but it's not in your lease. Hey, this tenant is in the pool at 11 o'clock. I don't want him in there. Well, do you have anything saying he's not there? He can't be there after 10. No, I don't. It's just a rule. Well, I can't enforce it. But if it's a house rule, you're not allowed to go in the pool for 10 o'clock. After 10, I can give a notice to kick him out because he's failing to leave the pool. So if there's certain things you want the tenants to follow, you need to set up your own house rules. Otherwise, I'm going to be stuck. Stuck meaning I won't be able to help you to kick them out because they're not doing certain things that you want them to do. Include all the required addendums, as you guys know, from pet addendum to smoking addendum to lead paint addendum to you name it. There's a bunch of things now that need to be required to be in your lease. Lead addendum, certain handbooks you have to give. The city of San Diego, every single person here should have already given the tenants the tenant handbook that's required, as well as the tenant disclosure. Whether you're exempt or not, in the city of San Diego, if you have not given them the book and you have not given them that disclosure, you're not allowed to give any notice to the tenant. He hasn't paid rent. Did you serve them the book and the disclosure? No, I didn't. I can't serve that notice to pay rent. Well, what do I need to do? You need to amend your rental agreement to include the book and the disclosure. Every lease, currently, every new tenant, when you sign a lease, has to have the book and the disclosure as part of the lease. It has to be included. Well, what if it's not? I can't serve a notice. I can't do a 3-day, I can't do a 30-day, can't do a 60-day. You are stuck. Okay? So if you haven't done it, do it. Can I email the book? Don't email the book. The statute doesn't say you're allowed to email the book. Hand them the book, mail them the book, mail them the disclosure. Okay. Longer is not always better. When the rental market is tight, meaning you don't have problems getting new tenants, the benefit of a long-term lease benefits the tenant more than the landlord. Okay? Right now, it's very tight out there. A 1-year lease, 2-year lease doesn't help you, it helps the tenant. If you come to me because you want to get rid of your tenant because they're doing X, Y, and Z, and it might not be technically a breach of the lease, it's very hard for me to get around a 1-year or 2-year lease. A month-to-month agreement is more flexible, so I'm able to do more things, or maybe it'll help you more if you have on a month-to-month agreement. Typically, a landlord wants to have a longer-term lease when the market's bad. I have a hard time getting new tenants, so I want to make sure my tenant stays there for at least a year or 2 years. That's to your benefit because you don't want the tenant to leave because he found a cheaper place down the road. But we know right now, your rent is probably a lot lower than what tenants can get out there in the open market, right? So the chances of them leaving because they got a great deal somewhere else is very low. So do month-to-month agreements. It gives me more flexibility what I need to do. If the market becomes really bad, start switching it up and doing 1 year lease or 2 year lease. We mentioned if it's not in writing, behavioral breaches are not enforceable. So if you want the tenant to do certain things, you need to put it in the house rules. Okay. So where can you get this stuff? Like I said, the AOA has all the forms, has all the leases. Any other type of rental association can also help you as well. The laws have been changing drastically all the time. And so really update your forms if you haven't done it in a long time. You have to include the exemption, non-exemption forms for California, and if you're a city of San Diego, you have those forms as well. If you don't provide these, there's certain penalties, right? You're not gonna be able to do certain things when you call me up. And there's nothing worse. He hasn't paid rent in 2 months. You call me up and say, I wanna start a 3-day notice. Did you serve the book? Did you serve the disclosure? No, I haven't. We need to do a change of terms of tenancy. It's gonna take 30 days. Once the 30 days expires, you lose another month's worth of rent. Then we can serve a 3-day notice. Then if he doesn't pay a 3-day notice, it's gonna take me 6 months to kick him out, right? So let's get all those things served on them. Other things to look for, attorney's fees clauses. You should not have an open-ended attorney's fees clause. What is the attorney's fees clause? The attorney's fees clause is basically says this: the prevailing party is entitled to their attorney's fees and court costs. Okay, so if you win in court, then the other side has to pay your attorney's fees and court costs. It's not a good clause to have in your contract, and I'll tell you why. Because it draws in attorneys on the other side, right? I know landlords do their best they can to do everything correctly all the time. Sometimes you don't. So let's say a tenant complains, oh, my heater doesn't work. You forgot about it because your wife got sick or something happened, you were traveling, and all of a sudden, 3 months later, you still haven't fixed the heater, right? Okay, you have an attorney's fees clause in there. And eventually, the tenant stops paying the rent, you serve him a notice, and then the tenant runs to an attorney, and the attorney goes, well, let me look at your rental agreement. Oh, there's an uncapped attorney's fees clause, which means tenant attorney is going to think, if I win, I'm going to make the landlord pay my attorney's fees. Tenant, you don't need to pay me anything because I'll get it from the other side because I think I got it. Or hey, let's say you make a mistake on your 3-day notice to pay rent or quit. It has to be perfect, the 3-day notice. If it's not perfect, you're going to lose. What does that mean? If you overstate the rent by 1 penny, you lose. So tenant runs, you serve a notice, you forgot your manager collected $50, or the manager forgot to tell you. Your notice is $50 over. You don't know this. You don't tell me, I don't know this. The tenant runs to the tenant's attorney and say, look, I paid $50, here's a receipt. I'm gonna take on the case. Tenant, don't pay me a dime. And eventually the attorney calls me up and says, you have a problem. What's my problem? They took $50, your notice is overstated. And what are you talking about? Here's a receipt. Client, what's this? Does this look like your manager's signature? Yes, it does. Manager, did you take $50? Yes, I did. Sorry, I forgot to tell you. Okay, we're already in litigation, right? And at this point, I might learn about it before trial, after discovery. Thousands of dollars are meant answering questions. And also on the other side, say, look, we want $10,000, right? Otherwise, one, you're gonna lose, and I'm gonna ask for more money because then I'm forced to do an attorney's fees motion, etc. I'm gonna go to my client, we're gonna lose. They want X amount. You pay it, or if you don't wanna pay it, we're gonna lose, you're gonna pay me more, and they're gonna charge more because eventually we're going to end up losing at trial. So see how, but let's say there is no attorney's fees clause, or the attorney's fees is capped at $500. You make a mistake. The tenant runs to the attorney. The attorney goes, okay, I might be able to help you, but I need you to pay me $2,000 to represent you because the most I can get from the other side is $500, right? Tenant says, I don't have $2,000. The attorney never comes into the case. The attorney never files motions. The attorney never serves me with discovery, questions, and documents that you need to produce for the other side. It reduces the amount of attorney's fees. If the litigant's just a tenant, there's a lot higher probability I'm going to resolve it, right? Because he doesn't have legal assistance at that point. So if you have an attorney's fees clause, take it out. If you want to cap it at a certain amount, that's fine. Attorney's fees up to $500, $1,000. It won't draw in attorneys on the other side. Another issue that's come, for whatever reason, become a big problem these days is addresses. Let's say you live in a house and you want to rent out a room in the house, right? and your house address is 1234 Main Street. So you come to the person and say, look, I'm going to rent you 123 Main Street, right? It's a room right here. Okay, great. The person that's renting out one of your room stops paying the rent. You come to me and say, hey, look, he's renting a room. He stopped paying the rent. Let me see the rental agreement. Well, here is 1234 Main Street. Don't you, landlord, also live in Main Street? Yes, I do. Well, you rented out the whole house to him. The tenant kicks the landlord out of the house. I rented the whole house. Can this happen? Of course, all the time. Kicks out the landlord. Well, you can't kick him out. Yes, I can. My lease says I rented out 1234 Main Street, right? What's the problem? The problem was the address. 123 Main Street, southeast bedroom, right? Or 123 Main Street, the back unit, right? Or whatever it is, you need to describe specifically what they're renting out. Otherwise, you can be stuck under a contract because you rented out the whole place. It's happened. I've been involved in cases a couple times. So be careful with the addresses or wrong addresses. A lot of people don't know the zip code to their properties. I don't know why. You need to make sure you know the zip code. You need to make sure what the main street or main avenue or main boulevard. They always mess up that part. You got to get that straight. Why is that important? When the sheriff does the lockout, they're going to go to Main Street, not Main Avenue. If they can't find Main Street, they're not going to go to do the lockout. It's as simple as that. So eventually, we check when we get the paperwork, does this 1234 Main Street exist? Great, if we find it, that doesn't solve the problem. There might be 1234 Main Avenue, right? So if you have the wrong address, it's going to trip everybody up, okay? So make sure it's correct. Owner occupancy termination clause. Right now, if you want to be able to have the right to have either you or a spouse or a relative, immediate relative moving into a unit, you have to have a clause in your rental agreement basically reserving that right. If you don't have that clause in your rental agreement, and let's say your mom wants to move back into her house that she's been renting out, I won't be able to use that as a reason to kick out the tenant. So if you want to reserve your rights, you've got to have that language in the lease. And you would have that language in the lease if you had an updated lease, right? All right. Assigning, subletting. Most people, this is okay. You have a strong clauses. It stops the tenant from assigning or subletting the space to someone else without your prior written condition, prior written permission. And so you got to be, just make sure it's in your rental agreements to stop them from doing that. Rent control, rent exemption. I think everybody knows about that. If it's exempt, you need to serve the notice. You need to provide the book. If you don't, even though your property might be exempt, it won't be if you haven't done the exemption notice. So if you have a house or a condo where the unit's built within the last 15 years and you could have been exempt and you don't give the exemption notice, you're not exempt and you're going to have to be subject to the rent control laws. Storage and parking. If you give them a storage space or a parking space, you need to identify it, right? A lot of times, so let's say he rents out a unit and he's parking spot 10. Put it in your agreement, unit 2B plus parking spot 10. Try to do it in the same agreement, right? If you have two different agreements, guess what? When you want me to kick them out, I have to file 2 evictions. If there's 2 separate agreements. If it's both on the same agreement, then I just do 1 eviction. Does that make sense? So a lot of times it's an apartment and a garage, right? Hey, you got apartment 2B and garage 3, which might not be connected to the unit, right? It's somewhere else. You got to make sure it's both on the same unit. It doesn't have to be, but again, if you come to me and say, I want to kick out 2B, okay, great. And by the way, he also rents garage 10. Here's a separate agreement. Okay, we need to do 2 evictions. But if it was on the same agreement, then it would just be 1. And you got to describe it. If it's storage, the tenant can put his stuff outside. That doesn't help. So let's say the tenant can store stuff underneath the staircase, the southwest staircase. That's a little bit better. Why? Again, the sheriff needs to know specifically where they're kicking people out of, what the particular area is. So if you can describe it, and if you have to use directions, do that. Sometimes it's an empty lot. Hey, I rented out that portion of the lot. Either you have to have signage telling the person what that portion of the lot is, that's lot 1, and I've named all the other 10 lots, or, hey, I rented to you the southeast corner of this lot, right? 100 feet by 100 feet. Great. The sheriff knows where to go. But if there's a big space and you rent out a section and the sheriff's like, well, I need to kick out somebody from this section. I don't know what section is on this property. It's going to be tough to kick them out. Okay, we're doing good. So my wife called me up recently and said, honey, I got some great concert tickets for 45 cents. I'm like, 45 cents? That's amazing. I go, what concert is it? And she said it was 50 cents featuring Nickelback. Okay, just a quick check. Move-in inspections. Okay, I can't stress this enough. A move-in inspection is basically you're giving the tenant an opportunity before they move in to inspect the premises and to tell you in writing what the problems are. If you can get the tenant to do this before you sign a lease, that would be the best. But I know sometimes you can't. But let's assume, hey, you've agreed to this applicant, they've signed the rental agreement, you have to do the move-in inspection. Get a move-in, move-out inspection list. I believe the AOA has that as well. If not, you can call my office. And it just basically lays out each room, all the stuff, the windows, the walls, the floors. The tenant goes, inspects everything, and jots down what the problems were. It's a baseline for what the condition of the place is when they first rented it. Why is it important? When we kick them out, or you're trying to give them none of the security deposit back because they left a lot of place damage, you want something to say what the condition was. So if they came in and said there was no broken blinds when they moved in, and then after they move out, the blinds were broken, you can prove that they caused it or their guests. If you don't have that move-in inspection, they're gonna say, it was broken when I moved in. You're gonna say, no, it wasn't, and then we have a fight going on. The move-out inspection sheet is important. So let them go through in their own writing, not yours. Again, when we're at trial, what's the best thing? Well, whose writing is this? Oh, it's the landlord's writing. Well, he didn't write down everything I said. Right? As opposed to, they wrote it down. Well, whose writing is this? This is the tenant's writing. They could have written whatever they want. They didn't say anything about the blinds. Obviously, the blinds were good, because otherwise they would have said the blinds were broken. Okay? The other thing I would do is take pictures of the premises before they move in. Back in the day, it was a pain. You got to develop film. It was a cost. Now there should be no reason why either you or your manager, before they move in, take a shot of every room, right, and just throw it in some file on the computer. Right? Because when it comes down to, let's say we're in the middle of eviction, tenant says he didn't pay the rent because the place is a disaster. I'm going to ask, do you have pictures before they move in? Did you have the move-in checklist? Yes, I do. Great, Your Honor. Here's the move-in checklist. The kitchen wasn't a disaster. The toilets were all working. There was no leaks. There's no mold, right? Because she would have noticed it on the move-in inspection. Plus, here's pictures before they moved in, and here's pictures we took when she complained about the problem. Right? So take the pictures. It's fantastic evidence. It helps me, 90% to win the case. One thing, strongly discouraged. If you don't learn anything else that I told you today, you're going to learn this one thing. Do not let tenants make repairs to your unit. What did I say? Do not allow tenants to make repairs to your unit. Why? It always goes bad. Hey, my heater doesn't work. Oh, don't worry about it, landlord. I'll take care of it. Never takes care of it. You never hear anything about it. We kick them out. Well, Your Honor, I told him about that bad heater, and it hasn't been fixed for 8 months. Well, tenant, you told me you're going to fix it. No, I didn't. Who's ultimately responsible to make sure the heater works? You are, right? And especially, let's say the tenant sent you an email. Hey, landlord, my heater doesn't work. And then you guys talk. Don't worry about it. I'll get it fixed. I don't really need it to work. Right? We had trial. He shows the email. Look, I notified the landlord 8 months ago. He didn't do anything. Well, I talked to him. He said he was going to fix it, or he said he didn't need it. I never said that, Your Honor. You're responsible to make sure there's heat in there. If there isn't, it's your fault, and you're going to lose. Okay? What's the other stuff? Well, tenant, I want to improve this and that, whatever. I'll pay you $5,000 to redo the kitchen. Right? You're making the tenant do the work. What's going to happen? He's not going to do it, right? It's going to be a mess. And then you're going to get subject to a claim that he's going to file with the labor department, right? That you didn't pay him enough for the work you said you were going to pay him, right? And on top of that, he worked 80 hours a week for 2 months, and he didn't pay you overtime as well. Well, landlord, did you tell him it was okay to do the kitchen? Yeah, I did. Well, he's claiming he worked X amount of hours, blah, blah, blah. Well, that's not true. Tenant's going to be like, no, I worked 80 hours. He was working me to the bone. He owes me $20,000 in unpaid wages, plus another $80,000 in penalties and overtime that he didn't pay. right? It's not good. And judges during the unlawful detainer process, they do not want to hear how you guys went back and forth about the kitchen for 9 months, whether or not he did the drawer right, whether he did the plumbing right. They don't want to hear that. They're going to be like, I'm a landlord-tenant judge. Was the rent paid or not? And the bigger problem the landlord does is like, I'll pay you $5,000, right? And I'll deduct it from your rent. The guy doesn't do the work. Well, is he entitled to the $5,000? I don't know. We're going to fight over whether or not the drawer was put in right or the plumbing was done right. It's just a mess, a hot mess. Don't do it. They're going to not do it right. They're going to hold it against you, and they're going to claim that you basically underpaid them what they were required. What can you do instead? My heater doesn't work. I'll fix it. No, that's okay. I don't really need it. No, we need to do it. Hey, heating, plumbing, gal, girl, I need you to go over there and make sure it's done, right? And show me proof that it's done. That's how you need to do it. Don't have the tenants do the work. Right now I'm involved in 2 or 3 cases. Tenants doing work. They're supposed to help remodel the inside for not paying rent for a year and a half. And it's just a quagmire, right? A quagmire because is the rent owed? Is the rent not owed? He's not happy with the work. He should be happy with the work. You promised me to do this. You didn't do that. It just becomes a nightmare. And if they get hurt, let's say they get hurt. They were drilling something and they got hurt. Are you his employee? Was he working as an independent contractor? Who provided him the tools? If you provided him the tools and you instructed him how to do it, he's not an independent contractor. He's your employee. Did you pay employee taxes for him? Right? You see how it becomes a nightmare? As opposed to you call A&M Heating. Obviously, they're independent contractors. They have their own business. They come out, they fix it how they want to fix it, and they use their own tools. There's no issue of whether or not this person is your employee or not. Okay, let's move on. Security deposit. This is something new, another law. Let's make this 18. July 1st, 2024. Basically, you're not allowed to ask for more than 1 month's in security deposit. Okay? There's an exception. If you're a small landlord, we're not talking like little people. We're talking means you own 2 properties with no more than 4 units total. If you own only 2 properties with at least 4 units or less total, then you can charge up to 2 months. Okay? Service members are also, regardless of where they're at, they're entitled to 1 month security deposit. Again, you're not allowed to add an extra pet deposit if they have an ESA animal. And typically, back in the days, you would ask for first month's rent, last month's rent, plus a security deposit. You're not going to be able to do that. You can ask for the first month's rent because it's the first month's rent, plus the 1 month security deposit. No more last month's. Okay? And don't play this game because it's not going to work. Hey, your security deposit is $1,500. 1 month's rent, but I'm going to charge you $50 for a key deposit. What else? Another $100 for this or that. You don't call it deposit, you just call it something different. Under the statute, no matter what you call it, if it's not rent, it's going to be considered a security deposit, which you need to account for. So whatever you call it, it doesn't matter. And in the statute, they have like 30 different things people call a key holding fund. I don't know what you want to call it. A garage door opener, whatever it is. You're thinking, well, it's not security deposit. I just charged $1,500. This is just for something else. Whatever you call it, it's going to be added as a security deposit. Does that make sense? Okay. Other problems you need to be aware of. Late fees cannot be excessive. Okay, what does excessive means? In the California State Constitution, they have you cannot charge usurious rates. In our context, for landlord-tenant, there's cases that have approved 5 to 6% as the late fee being okay. Okay, so if your rent's $1,000, your late fee can't be above $50, $60. I've seen rental agreements. I'm going to charge you $100 per day. That's not valid, right? Well, how can that get you in trouble? Well, the tenant's there for 3 years, and you keep charging him. Let's say he's late 3 days, $300, $400, $500. You come to me and say, "Hey, I want to do a 3-day notice to pay rent and quit. I notice your late fee provision is illegal. Hey, all this stuff is too high." where you have to figure out all the late fees you paid the last 3 years, the tenant paid, deduct it from what he owes you, and see if there's anything left over, right? Because as we go forward with the 3-day notice and not giving him that money back, if some attorney comes back and says, hey, this late fee is illegal, and he paid $500 in late fees last week or last year, your notice is overstated. Remember, if it's overstated by 1 penny, you lose. Okay, so take a look at your late fee provision. And be careful about the daily late fee. Well, it's on a $1,000 rent, it's $50 per day. What's the problem? Well, $50 times 30 is $1,500 on an annual basis. That's whatever it is, 5,000% interest, right? Let's move on. Utilities. This is becoming a pain also for people. Here's when it becomes a problem. You have multiple units and they all share a meter. Ideally, what I would prefer is you just increase the rent, if you're able to make up what your water bill is with the tenants, right? So let's say you have 4 units, 1 water meter, okay? Ideally would be like, look, my water bill's $400 a month, let's say. I'm just gonna increase the rent $100 per unit, right? Or when they come in, just add an extra 100 to what I was gonna normally charge, and then I'll pay for the water bill. That would be ideal. Second to ideal is you can hire companies that will come out, measure everybody, measure the whole property, see what the tenants use, see what you use as a landlord, like for common areas, figure out how many people are in each room, each unit, and then they'll do a calculation and spit out and say, look, our water bill's $400, you have 5 people here, you're gonna pay $112, you're gonna pay $80, and do it that way. The courts are okay with that, right? The RUBS system, it's called RUBS. What usually happens and where people get in trouble is, hey, tenant, bill's $400, everybody's gonna pay $100. Well, I live alone, this person has 9. How do you know, landlord, that my water usage was the same as this other guy's water usage and that I actually use $100 worth of water? If you can't prove that they actually use $100 worth of water and you charge them for it, we're gonna have a problem. Why? We do a 3-day notice to pay rent or quit. I can't prove that $100 they actually use $100 of water. They might have overpaid. If they overpaid 1 penny on the water, that means the rent 3-day notice is overstated by 1 penny and we lose. Okay, so you can do sub-metering, a sub-meter for each unit, but that's very expensive, right? If you're gonna do something separately and you wanna go down that path, you can do the RUBS, or you're gonna have to have a separate agreement with that tenant outlining what the rights and duties are of each party. Let's save it for the end. We're almost done. So what am I trying to tell you? Make it part of the rent is easier. Try to use RUBS. RUBS works great for larger apartment complexes. If it's something smaller and you want to do a side agreement with somebody, then you need to have a separate agreement that deals specifically with that utility. And your failure to disclose this, that, hey, tenant, by the way, you're potentially paying for water for other tenants, and you're actually paying water for me to water the common area lawn, then you might be subject to penalties. Okay? Garage, parking spaces, we talked about this a little bit. Try not to make it separate agreements. Let's say he rented a unit and then subsequently wanted to rent a garage or a storage area. What I would do is just work up a new rental agreement, right? New rental agreement for unit 2B and include the parking spot and the storage space. And storage provisions, try to be as tight as you can on where it's actually located. So I know this was a lot of information. This is going to be posted on my website.